So welcome to the third webinar in the spring series, and actually the penultimate webinar in our series, Contemporary Challenges in American and Global Law. I'm Leah Wortham, Professor Emerita of Law at the Columbus School of Law of the Catholic University of America. I'm the Catholic University Director of the American Law Program and the LLM program in American Law, in which Jagiellonian University and Catholic University have cooperated for many years. I will be your moderator. Christina Lopez, Director of Advancement in the Law School's Development and Alumni Relations Office, will bring greetings from the Columbus School of Law of the Catholic University of America.
Thanks so much, Professor Wortham. And again, thanks for your creativity and execution of these really outstanding virtual programs. Today is the 15th program in the series. That's amazing. The partnership between Jagiellonian University, one of the best law schools in Poland, and Catholic Law School has flourished under Professor Wortham's really strong leadership. The 30-year relationship really has deep roots and has been really invigorated by this web series program over the past year. Catholic Law and the Jagiellonian University's model partnership, of course, was founded by Emeritus Professor Ludwikowski. Welcome all today. We have over 130 participants registered. I'm not sure how many have joined at this point, but it's certainly a lot. We have the alumni of the International Business and Trade Summer Law Program that we're welcoming, the American Law Program, and the LLM in American Law. We now have more than 2,000 US, Polish, and other international alumni from the program. As with each of these programs, our panelists today are really superb. Today, we're really looking forward to hearing from Professor Regina Jefferson and Professor Elżbieta Karska from Warsaw. On their discussion, they're talking about retirement savings policy through the lens of international human rights. We thank you, and thanks for being with us, speakers, alumni, and I'm going to turn it back over to Professor Wortham.
Thank you. Wojciech Banczyk, Coordinator of the American Law School, will welcome you on behalf of Jagiellonian University.
Very much. Dear participants of the series of webinars, it's a great pleasure for me to express on behalf of the Jagiellonian University the undeniable happiness that you all joined us in the online meeting, showing your interest in the contemporary challenges in American and global law. We are glad to observe, again, a huge audience who shares our passions. All our meetings here allow to hope for many common undertakings in the future. At the same time, we look forward to developing cooperation of the Jagiellonian University and the Catholic University of America will continue, and new programs, as we do hope, will soon revive after the pandemic. Thus, we have already launched recruitment for the next year's American Law program, and we look forward to many live events after this series of online meetings. At the same time, we are very proud that the transatlantic cooperation strives in this form, even during the pandemic, despite the technical problems and without the possibility to meet in person. This position lets me to express the great gratitude to all the persons without whom it will never be possible for this event to happen, in which, at least in this form, we are able to see one another and discuss issues which we are all interested in. To reassume, we are very excited with a new way to learn and to meet together. At the same time, we do hope that hopefully much sooner than later, we will meet in person during our programs or alumni events.
Thank you so much. This webinar series is a team effort, starting with the support of Dean Stephen Payne of Catholic University and Dean Jerzy Piszylinski, Dean of the Faculty of Law and Administration of Jagiellonian University. It draws on the leadership and staff of the Jagiellonian Center for Foreign Law School Cooperation, often referred to by its Polish acronym OXPO. Catholic University and Law School and Development Relations and Communications offices have been critical, as well as our LLM coordinators and graduates, Gaspar Cote and Luke Bartosik. The links for the final webinar in the series is available on the series website, as well as recordings for past webinars. In our final webinar on June 5th, we will return to policy and regulation of investment funds, on which we've had several related lectures in the past, with LLM graduate Victor Furman, who practices law in Stockholm, Sweden, and with comments from CUA JD alum and partner in the Deckert firm, James Catano. We are cautiously optimistic about returning to the live American Law program in our normal schedule in the fall. In the chat, you can see links for information sessions on May 26th at 3 p.m. Polish time and Thursday, June 17th at 7 p.m. Online entrance exams are scheduled for Wednesday, June 9th at 3 p.m. and Thursday, July 1st at 7 p.m. The entrance exam is waived for people who have attended 12 of these webinars and received our certificate, and for students who are matriculated in the LLM program. So now we turn to today's program by Professor Jefferson, followed by comments by Professor Karska. I expect most of you have used Zoom before or a similar video conferencing platform, so you know about typing questions in the chat. I'll be taking those questions from the chat and posing them to our speakers. You can type your correct question directly there, or if you prefer, you can direct it privately to Wojciech Banczyk or to Gaspar Cote, and they will pass it on. If you can also do a private chat, if you see an old friend or colleague is on the participant list, you can choose that person's name and send them a private chat as well. Professor Jefferson will speak for about 20 minutes. She will be followed by a comment from Professor Karska, who will also lead off the question and answer period. The session is being recorded, and the 60-minute webinar, the first 60 minutes, will be posted on CUA's YouTube channel within a few days. The series website links to those recordings, and there are also stories about the series on CUA Law's website. At the end of 60 minutes, I will close the formal webinar and the recording will cease, but we will just continue right on. And Professor Jefferson and Professor Karska have graciously agreed to stay on for up to half an hour so we can take more of your questions. So I encourage you, any of you who would like to stay on for more questions and discussion, to do so. In the chat, you will now see links for bios for Professor Jefferson and Professor Karska. And I will just introduce them briefly with some highlights from those longer bios. Professor Jefferson is a nationally recognized expert in pension law, employee benefits, and tax law, and teaches courses in those areas. In 2015, she was appointed by President Obama to the Pension Benefit Guarantee Corporation's Advisory Committee and is now serving a second term. She's testified before the US Congress and briefed congressional staff on employee benefits and tax topics. She has served as Dean of the Law School, as well as Associate Dean for Academic Affairs. Professor Karska holds doctoral and postdoctoral degrees in law. She is a professor of law at the Faculty of Law and Administration of the Cardinal Stefan Wyszyński University in Warsaw, where she heads the Department of Human Rights Protection and International Humanitarian Law. She also directs the university's doctoral school. She is former director of the Law Faculty's Institute of International Law, European Union, and International Relations. She holds or has held positions on important European and international institutions concerned with human rights, including the following: members of the Council of Europe's Commission Against Racism and Intolerance, member of the Management Board of the European Union Agency on Fundamental Rights, expert for the OSCE Office of Democratic Institutions and Human Rights, an expert and working group member, including the chairperson rapporteur of the United Nations entities involving human rights, and an ad hoc judge of the European Court of Human Rights. She has written more than 100 publications on international law and European law, many of them on human rights law, as well as serving on editorial and advisory boards of several academic journals. She holds honorary doctorates from universities in Armenia, Georgia, and Ukraine. So I now turn to Professor Jefferson.
Thank you very much for that introduction, and thank you also for inviting me to speak in this webinar series. It is a pleasure to be with you today and to discuss the topic, is retirement a human right? The American tax system contains numerous provisions designed to encourage activities consistent with certain public policy concerns and to relieve various forms of personal hardship. These provisions, referred to as tax expenditures, have significant economic and social impact. They represent a set of societal beliefs that some activities are so important that they warrant public subsidies and also justify the substantial revenue foregone in connection with the activities that they support. Not surprisingly, much of the debate surrounding tax policy relates to questions about the types of activities that government should support, the manner in which governmental support should be structured, and the extent to which such support should be provided. Using an international human rights framework, my talk today will consider these questions as they relate to the American private retirement system, which is one of the United States' largest tax expenditures. My presentation is based on an article I wrote titled, "Let Them Eat Cake: Examining United States Retirement Savings Policy Through the Lens of International Human Rights," which was published in the Harvard Human Rights Journal in spring of 2018. The American private retirement system historically has been successful in providing retirement security to a cross-section of American workers, many of whom could not have saved for retirement on their own. However, a confluence of economic, social, and demographic changes over the last 3 decades has negatively impacted the private retirement system and has rendered it unable to provide retirement security for millions of American workers. This is especially the case for workers who are low and middle income. The adverse economic and social repercussions of the COVID-19 pandemic this past year have made saving for retirement even more difficult. This situation has exacerbated existing social and economic inequalities and has widened the retirement income gap between higher and lower income workers. The American public retirement system, Social Security, also faces challenges. Since its inception in 1935, this program has been very effective in reducing elderly poverty in the United States. However, the program currently is experiencing a funding shortfall that threatens to erode much of its success. The combined effect of these developments has created a retirement savings crisis in the United States that poses a threat not only to the financial security of families and communities, but also to the dignity of individual workers in their old age. The retirement savings crisis cannot be resolved simply by instructing individuals who have limited resources to save more retirement, any more so than a famine can be eliminated by directing individuals who have no bread to eat cake, as Marie Antoinette reportedly did during the French Revolution. The reality is that some workers have competing consumption needs that prevent them from being able to save for retirement. As a result, when many of these individuals reach old age and are no longer able to work, they will have insufficient assets for financial security and to live their lives in dignity through no fault of their own. The Universal Declaration of Human Rights, the most significant source of human rights law, provides that every living person has a right to an adequate standard of living. Other sources of human rights law require governments to generate the maximum available resources for the progressive realization of civil, political, economic, social, and cultural rights. Additionally, the United States Principles for Older Persons specifically provides that older people should have access to adequate food, clothing, shelter, and healthcare. Therefore, the retirement savings crisis has both economic and moral implications. It raises questions about the effectiveness of domestic retirement savings policy, as well as the willingness of the United States to promote and protect internationally recognized human rights for its elderly population. Framing retirement savings policy in the context of internationally recognized human rights, rather than traditional economic theory, provides an additional framework within which the government's policies regarding retirement can be evaluated. It is my hope that by making this connection, policymakers will, 1, seek more equitable and effective distributions of retirement benefits, and 2, realize that reliance on self-help approaches to retirement savings in the United States, one of the richest countries in the world, without allowances for workers who have insufficient income to save, is incongruous with established human rights principles. The remainder of my remarks will be organized as follows. First, I will provide an overview of the recent history of human rights law and the recognition of human rights for elderly. Second, I will analyze and critique the current retirement savings system through the lens of international human rights law. Third, I will compare and contrast the private retirement system with the Social Security program. And finally, I will briefly address the need for pension reform and broadly describe a proposal designed to achieve greater retirement security by advancing recognized human rights principles. Special categories of human rights have developed for certain groups over time because of the unique and persisting challenges of their circumstances. The elderly population is such a group. Throughout the world, older individuals continue to disproportionately face discrimination in employment, access to credit, abuse in the home, and violence in public arenas. As a result, a body of human rights law has emerged that explicitly focuses on the rights of the aged. The Universal Declaration of Human Rights states that every person has a right to an adequate standard of living in the event of unemployment, sickness, disability, widowhood, old age, or other lack of livelihood in circumstances beyond their control. This language sets a common standard of achievement for all people and nations, and explicitly includes the elderly among populations that warrant special attention regarding their basic human rights. In 1978, the United Nations formally recognized the issue of human rights for the elderly when it funded the World Assembly on the Elderly. Subsequently, in 1982, the Assembly adopted an international plan of action on aging that asked member countries to review their laws and policies relating to the protection of rights for the elderly. Almost a decade later, in 1991, the United Nations Principles for Older Persons was adopted. The Principles for Older Persons explicitly asserts the rights of the elderly and encourages governments to incorporate in their social programs principles that promote independence, full participation, healthcare, self-fulfillment, and the ability to live with dignity and security. This document specifically states that the elderly should be afforded adequate food, clothing, shelter, and healthcare, as well as appropriate support services. Thus, as a matter of public policy, it is very important for government to encourage workers who can save adequate amounts for retirement to do so. For individuals who cannot afford to save on their own, however, it is important for governments to provide additional assistance. As a matter of pension policy, there also is a need to protect money saved for retirement against risks such as unexpected longevity, market volatility, and inflation, which all have the potential to erode the value of one's retirement savings. The United States private retirement system is voluntary, employment-based, and tax-preferred. The system was designed to incentivize and protect retirement savings, with each of its characteristics playing an important role in the function of the program. The fact that the private system is voluntary makes it necessary to provide incentives to encourage employers to establish and maintain qualified retirement plans. This creates tension between having stricter rules about participation and coverage rates on the one hand, and not deterring employers from offering and maintaining qualified retirement plans on the other. Because the system is employment-based, the receipt of benefits from the private retirement system is uncertain. As a result, plan coverage often bypasses a significant percentage of the labor force. For example, low-income workers are more likely than high-income workers to be employed in industries that do not offer retirement plans. They also have higher attrition rates. These variances and trends in employment practices have significantly widened the retirement savings gap relative to income. Although tax preferences are necessary to incentivize employers to establish and maintain retirement plans, they raise serious concerns about the fairness of the program. Deductions and tax deferral are more valuable to workers who have higher marginal tax rates. This disparate impact contributes to lower coverage and participation rates among low and middle income workers in the private retirement system. This is particularly apparent in the new 401k plan dominated landscape, where participants choose both whether and to what extent they contribute to their employer-sponsored plans. Tax policy can play a fundamental role in the redistribution of national resources. Consequently, it is not uncommon for governments to use tax expenditures to further human rights objectives to address economic inequalities. In an effort to assess the effectiveness of various tax programs and policies used throughout the world for this purpose, the United Nations submitted a questionnaire to member states to help evaluate the impact of fiscal and tax policies on human rights. Based on this questionnaire, a report was created to identify trends and policies and also to highlight human rights concerns. The report included responses to the following 3 survey questions. 1. Is your government's tax policy compatible with its obligation to use maximum available resources to realize economic and social rights? 2. Is your government's tax structure regressive or progressive? And 3, are there special mechanisms in place to protect marginalized and vulnerable groups in accordance with principles of transparency and non-discrimination? Although the questions were written to elicit responses regarding the relationship of human rights principles to broad fiscal and tax policies, applying these questions to the United States private retirement system is useful in evaluating the program's impact on the human rights of the elderly. Regarding the first question, the United States private retirement system does not appear to fully maximize available resources in order to realize economic and social rights for all citizens. There are 2 primary reasons for this conclusion. One is because the program is voluntary, which leads to lower coverage rates for low and middle income taxpayers and greater benefits for taxpayers with higher marginal tax rates. The second reason relates to the reallocation of risk associated with the shift from using traditional defined benefit plans to 401k plans as primary retirement savings vehicles. In defined benefit plans, a guaranteed retirement benefit is promised, typically in the form of a life annuity. In these plans, the Pension Benefit Guaranty Corporation, a federal agency, ensures a limited benefit in the event that an employer becomes insolvent and is unable to pay the promised benefit. Therefore, in defined benefit plans, the employer is primarily liable and the government is secondarily liable for the payment of retirement benefits. In 401k plans and other defined contribution plans, which have increasingly become the dominant plan type used in the private sector, there is no federal protection against plan losses. The benefits payable at retirement are determined by the employee's account balance. The failure to provide some form of guaranteed benefit in 401k plans effectively reallocates the risk associated with retirement savings from the government and the employer to the participant. This shift would not appear to maximize resources for the advancement of economic and social rights, as it places greater risks on individual workers who are less likely than the government to be in a position to protect themselves. Regarding the second question, the United States private retirement system cannot accurately be described as progressive. All taxpayers, including the least wealthy, subsidize the preferential tax treatment of the private retirement system by paying higher taxes on the portions of their incomes that do not receive special tax treatment. Therefore, the private retirement system currently redistributes income from those without coverage to those with coverage. This generally results in redistribution from low-income workers to high-income ones, which is patently inconsistent with the concept of progressivity. Regarding question 3, one of the primary criticisms of tax expenditures is that they are more esoteric and opaque than direct payment programs. Consequently, as a tax expenditure, the private retirement system cannot be described as transparent in either design or operation. Unlike direct payment programs, which are visible to the public, programs supported by tax expenditures are less apparent because they are buried in the tax law. As a result, these programs are more insulated from public debate and scrutiny than our direct expenditure programs. The private retirement system also cannot accurately be described as non-discriminatory. Employer-sponsored plans are subject to non-discrimination rules. However, there is a level of permitted disparity that allows qualified plans to disproportionately benefit highly compensated workers. The safe harbor test for non-discrimination in 401k plans lessen the employer's administrative burdens and allow even greater discrimination in favor of highly compensated employees. Although the non-discrimination rules are not per se inconsistent with desirable pension policy, they do raise questions about whether the degree of permitted disparity in the private retirement system is justifiable. In summary, based on the 3 survey questions discussed above, human rights principles seem to have little impact on the United States private retirement system's structure or operations. Social Security is one of the most successful and popular social programs in United States history. The program has been particularly effective in reducing poverty among the elderly. Social Security retirement benefits initially were designed to be only a safety net for the elderly, supplementing other sources of retirement income. As of 2015, however, 62% of retired households rely on Social Security benefits for more than half of their total income, with 34% of retired households having no other significant source of income. Congress established the Social Security program with 2 primary objectives. The first was to provide a minimum standard of living to the elderly, the disabled, and their dependent survivors. The program's second objective was to help moderate the decline in living standards when workers lose wages due to retirement, disability, or death. This latter focus is a direct response to the obligation under human rights law to affirm human dignity and protect basic economic and social rights when individuals are unable to provide for their own basic needs. Many of the Social Security program's features support human rights principles and the areas addressed by the United Nations survey regarding tax policy and human rights. By making the Social Security program mandatory, the government draws upon the earning power of the entire workforce to provide support for retirement needs of the nation's elderly and disabled. By providing universal coverage and guaranteed benefits, workers are assured of having some means of procuring basic needs and services in old age, regardless of the investment performance of the funds or the timing of their retirement. Because the normal form of payment in the Social Security program is a life annuity, workers are protected against the risk of outliving their assets, a form of protection increasingly difficult to find in the private retirement system. Cost of living adjustments also make the structure of the Social Security program more compatible with human rights principles as it ensures that workers do not fall into poverty as they age. Although the Social Security program is an important source of retirement income and incorporates many human rights principles, the program's benefits are relatively modest by international standards. As of May 2017, the average Social Security retired workers benefit was nearly $1,400 per month, or approximately $16,400 per year. Represented as a percentage of median earnings, the replacement rate of the United States Social Security program ranks 31 among a list of 34 developed countries' public retirement systems. Social Security benefits in the United States average only 41% of the earnings of a middle-income worker, as compared to about 90% in the Netherlands and to an overall average of 57.9% for all OECD countries. The impact of poverty is especially devastating in old age when it is often no longer possible to work. Social, economic, and human rights principles should all play key roles in helping workers to save adequate amounts for a dignified life in old age. This need is particularly compelling for those who cannot afford to save on their own. Therefore, efforts should be made to reform the existing private retirement system to provide greater retirement security for workers in old age, to correct structural inequalities in the private retirement system, and to meet internationally recognized human rights obligations for the elderly. Retirement security involves 2 critical components. One relates to adequacy and the determination of how much an individual needs to save, often referred to as the replacement rate. As a general rule, the optimal goal is to save at least the amount necessary to sustain a pre-retirement living standard. The other component of retirement security relates to the methods used to achieve the targeted amount and the available mechanism for protecting saved amounts against losses prior to retirement. This component is far more complicated because it relates to uncertainty such as life expectancy, health, inflation, market volatility, and employer insolvency. Consequently, some level of governmental oversight and assistance is appropriate and necessary to achieve this goal, as the government is more capable than most individuals of providing protection against these types of uncertain events. Moreover, because of economies of scale and risk pooling, it is more efficient for the government and employers to provide various forms of assistance in an effort to achieve greater retirement security. Presently, the private retirement system is not required to provide participants in 401k plans any assistance in accumulating or protecting their retirement savings. In contrast, Social Security provides workers protection against all forms of risk associated with retirement savings. Moreover, key human rights principles such as universality and progressivity are fundamental to the structure of the Social Security program. Although the private retirement system continues to be an important source of retirement income for many workers, there are serious deficiencies in the system regarding the benefits of low and middle income workers. This situation raises serious concern about both pension and policy goals and human rights obligations. Thus, as policymakers address the retirement savings crisis, they should think more broadly about the relationship between retirement security and human rights, the role of government, and the responsibility of the community to individuals. A one-size reform approach does not fit all, however. Appropriate distinctions must be made among workers relative to their abilities to save for retirement. I believe that expanding and strengthening the Social Security program is the most equitable, effective, and efficient way of providing low and middle income workers greater financial security during old age from both a pension policy and a human rights perspective. This expansion would include measures such as increasing the Social Security program's minimum guaranteed benefits and indexing the minimum benefits for inflation. For workers having the ability to save, protection against losses should be added to the private retirement system to provide greater retirement security. This form of protection would be designed to prevent workers from suffering losses due to mistakes, miscalculations, and catastrophes for which individuals often are incapable of coping alone. Thank you so much for your attention. I will stop here and turn the floor over to Professor Karska.
Thank you so much, Professor Jefferson. Before we hear from Professor Karska, I wanted to recognize a few people we have with us today. I'm very pleased that we have three of our American Law Program professors, Professor Duggan, Professor Richard Pelt-Steele, and George Garvey, who was also the founder of the American Law Program, and we're very pleased to have them with us today. I also want to recognize our alum, Phyllis Borsey, who was in the Obama administration, the Assistant Secretary for Employee Benefits at the Department of Labor, which made her the administrator of the Employee Benefits Security Administration. Hello, Phyllis, she's turned on her camera. So we're glad to have another distinguished expert on US retirement policy with us today. I also wanted to mention Professor Karska is an alum of our International Business and Trade Summer Law Program in Krakow. In addition to that program, we also have an International Human Rights Program in Rome. And I wanted to mention that Professor Jefferson, who has taught in that program several times, that actually developed the article I think she's basing this on from a course she taught in our summer program in Rome. So, and we very much hope both of those summer programs are returning next summer, and we will be able to offer them to students again. So I now turn to Professor Karska.
Thank you very much. First of all, let me thank you very much for inviting me to participate in this web seminar. It is an honor and a pleasure for me also as a participant and graduate of Summer Law School at the Jagiellonian University and Catholic University of America. So I was a participant in 2000 year, which that was very interesting experience for me. And I really want to tell you that this program really formates people, formates our students for future research, for future work at the university, but also in practice as practical lawyers in Poland. I would like to, first of all, to congratulate Professor Jefferson of her very interesting article, and it is an honor for me to make some comments. The first comment is that I fully agree with your especially critical remarks about the social security system. I'm very happy personally that you raise the problems that in practice appear with respect to human rights, because in the perspective, from the perspective of international law, from the perspective of United Nations and many aspects of the problem of elderly people that have been discussed in United Nations Human Rights Council and in special procedures, which are very, very close to me, this problem, this aspect of pension system, retirement system, social security system, it is a very important aspect of the discussion. So first of all, I would like to start from the very interesting, very important point. In 1935, when the system was created, I think it was created as a subsidiary system in nature. So maybe today we could discuss, we should discuss the problem of its flexibility, to what extent it is able to adjust to new challenges, new problems, new demographic challenges. So that is the nature of the system as a subsidiary to private savings, and some help, I would say, in general from the family, or it hasn't been, it wasn't, I think, created as a one system which could be available and could work on for elderly people as such. From the international perspective, I fully agree with Professor Jefferson, who told us that it has a little impact of UN principles. Professor Jefferson also enumerated UN documents that were adopted by this system. I would say even more, those principles were adopted but international community is aware that those principles are not fully implemented. And Human Rights Council has implemented two tools in order to work on implementation of UN principles on elderly people. So first is the mandate, special procedure mandate on elderly people. So this mandate was created by Human Rights Council with that purpose, how to improve the situation of elderly people all over the world, to what extent this mandate may have an impact on the policy and better implementation of UN standards of elderly people. This is one question. The second question refers to intergovernmental process on the adoption of the internationally binding instrument on the status and living conditions of elderly people. So the second intergovernmental process is not easy to finalize. It is not easy to go through political difficulties because we have internationally binding instruments. So this is always difficulty to persuade states to have new and more international obligations, including obligations on the adequate standard of living of elderly people. But we have to be aware of the situation in many countries all over the world. And this is the hard work of the special procedure mandate holders that that in many states there is no pension system, there is no social security system at all. So we are aware of those difficulties, and we really try to improve the situation in those countries where the pension system is not adequate or does not exist at all, unfortunately. So having in mind difficulties, the adequate standard of living, and the possibility of improving the situation of elderly people, I would like to raise also the EU aspect. So EU regulation adopted on the social security system allows, for example, on trans-border investment. So that is the new challenge, the new challenge for EU member states, how in practice develop that system, because we are 27 different member states and different social security systems. So this is very interesting topic. This is the topic that raises a lot of questions from the perspective of human rights law. And everything is connected with practical progress and practical question. What is the role of private system, the private part of that system? So in practice, this is also very, very interesting. What is the recommendation, how to develop those parts of the social security system in practice in order to improve the level of the protection of human rights, the aspect of adequate living standards, and in general, how to improve the financial situation of elderly people in order to improve the level of the protection of human rights. These are my first questions that I would like to raise both to Professor Jefferson and our participants. Once again, thank you very much for inviting me to be with you, to take part in this seminar. Thank you very much.
Thank you so much. And I now turn back to Professor Jefferson.
Well, let me begin by thanking you for those very thoughtful comments and thoughtful questions as well. And I think you raised some very interesting points. One, before answering your question about the role of private retirement, the private retirement system, and how can we, respond through the public retirement system, I would like to go back to the point that you made about flexibility. And I think this underlies the answer to the questions that you raised. And I do think that the whole retirement system does have to be flexible, just as you mentioned. Initially, we thought that there were three primary sources of retirement income, and those sources initially were separate and distinct. One was Social Security, which is, as we said, the public retirement system. One was the individual's own private savings, just what they managed to save, which in some literature includes even home equity or home ownership. And then third was the private retirement savings systems. And so those initially, we often used what was called the three-leg stool as a metaphor to represent all three sources of income. And I think all of those legs were important to having a secure retirement. Today, the legs are a little bit wobbly, one might say. As we pointed out, Social Security is facing some challenges with respect to funding. Private savings, certainly in the United States, has significantly gone down over the last few decades. And then the private retirement system has changed from providing defined benefit plans, which gave people guaranteed benefits, now to more of a 401k regime where people make the choices about whether to participate, how much to participate, and in some cases, even how to invest. And so notice that is a totally different landscape. And so this is why I think it's incumbent upon policymakers to recognize that we must have flexibility. We must change, because what used to be is no longer the case. We don't have these three discrete legs. The legs that we do have, as I said, are somewhat strained with respect to some of the challenges. And so I do believe that the role of the private retirement system is still there, but it's been redefined. I think now the private retirement system is really there to not provide benefits for, as I mentioned in my remarks, low income and middle income people, but it's there to really help maybe upper middle income people who certainly still need some assistance saving. Using those numbers, I think, is a little bit vague without giving some context. And certainly it varies from even state to state, country to country, what is considered low, middle income, what is considered low income. But if we use numbers such as below 50,000 is low income, and for a family of four, and below 140,000 for a family of four is middle income, you can see that the private retirement system, I think, even though I was critical of it, I think it has an important role to supplement other sources of income, and also to incentivize people who have the means to save. So I do believe it has a very important role. But here again, as I said, one size doesn't fit all. It has an important role for some people, but I don't think it will help people who have low income to be able to save in this 401k, I guess, landscape where people make choices to save and they have competing consumption needs. So in that regard, I think it has a role, but not necessarily for low and middle income individuals. With respect to, I think, your second question, which was what can we do with respect to the public retirement system, Social Security, to make it more successful in providing benefits to low and middle income people. And I think two of the things I suggested was, one is to increase the minimum benefit. I think by doing that, it ensures that anybody who has worked, has a consistent work history, would be assured of having enough income to meet their basic needs. And also, I think it's important to have a mechanism by which we index these amounts to keep the workers from falling into poverty during a lifetime. In other words, we know that life expectancies are now a lot longer than they used to be. People will be in retirement a long time. Therefore, it's important to keep those minimum benefits, I think, indexed, using maybe not just the regular consumer price index, but certainly to use things that reflect maybe seniors' patterns of spending. So I think those would be my responses to your questions.
Thank you so much. Oh, we have a question from Professor Duggan that goes to Professor Jefferson. She says, thank you for your wonderful informative talk. Your analysis of the 3 UN survey questions seemed very insightful to me. I wonder, she has a question about how our government answered the question. If the US has, who answered the question? If the US has answered them, could you comment on the difference between an official answer and your analysis? And do you think most members of Congress understand the regressive nature of US laws in this area and the need to reform the private retirement system, especially for low and middle income Americans?
Okay, thank you as well for that very for those thoughtful questions. I guess I have one disclaimer to give about the questionnaire, and as I mentioned in my remarks, the questionnaire really was targeted to broad fiscal policy. In other words, it wasn't focused on specific retirement. It was really looking at just all tax expenditures to see how they advanced human rights. And so I, by analogy, used those questions to analyze our retirement system. And so though it was not really used for that purpose, it was, as I said, by analogy. So we don't have an official, to answer your question, there is no official response from the United States or even other countries specifically about their retirement systems. It really went more to just broader fiscal policy. And the second part, I think, of that question is, no, I'm not aware exactly of how the United States responded in the context of its broad fiscal policy. Your second question, could you repeat that for me, Leah?
It was, do you think most members of Congress, I don't know if any of us are able to psychoanalyze members of Congress, understand the regressive nature of US laws in this area and the need to reform the private retirement system, especially for low and middle income Americans?
Well, I think I'm going to use the law professor yes and no answer on that one. I do believe that, yes, that some do understand, but I think it's very helpful to remind people about that, because certainly employee benefits is a very technical area. And so even, I would argue, even if one appreciates progressivity in normal tax literature, I think that's in some ways the retirement benefit is a little different. And so maybe having a more nuanced view, that would be helpful. So I think that they may understand it, but I think it would be helpful to remind them of how it applies maybe in the employee benefits field or specifically in the private retirement system.
Great, thank you. We have about a few minutes left before we cease the recording. I'm going to actually alert both Professor Jefferson and Professor Karska to a couple of questions that I think will actually turn off the recording first, just so we're not catching you in the middle of them. So first, I know a little bit about the history of Social Security in this country, that, from the 1930s. And one of the things that, of course, has been an issue is some of the discriminatory nature of who was covered and who wasn't when it first went into effect, and what some of the big holes in the system have been, because even though it's a very, in one sense, universal system and has gotten more universal, I think it's still not completely universal. So I was going to ask Professor Jefferson to address a bit kind of holes in the system that, might still exist in terms of how universal it is, although I think some of the past has been corrected. And I realize Professor Karska is a human rights expert and probably doesn't consider herself a retirement expert, but I don't actually know so much about the Polish retirement system. So if there are any comparable questions about the universality of coverage in Poland, I thought perhaps she can address that, as well. The second thing I think we could take up in the latter half is the relationship of medical benefits to public retirement systems, because of course it's rather interesting that even though the Social Security system in the US is somewhat inconsequential for upper middle class people, as Professor Jefferson says, the amount of benefits are low enough that a lot of middle income and certainly upper middle income people really are retiring, have other retirement plans, which are what are important to them. But the Medicare system is something that is pretty universal. I mean, really many people at all income levels. And so it's an interesting question about why the US in some ways developed more expansively toward the medical benefits we provide to elderly people than we have to other kinds of retirement. And, you know, I realized that wasn't what you were writing about, and but we like that touches on some of the same issues. And so if there's any comments that Professor Karska wanted to make in that regard, that would be fine too. So I just want to remind you that we do have the 2 information sessions that are in the chat for the American Law Program that are coming up. You can go to the Facebook page and see those dates, as well as the online exams that will take place. We hope some of you who've been joining us will get that information. And of course, many of you have been on enough of them that you now have a certificate and don't have to take the exam. So I'm going to go ahead and cease the recording so we don't interrupt them in the middle of the answer to a question.